Good morning to everyone. I welcome Honorable Justice Vaidyanathan, Honorable Justice Anand Venkatesh, and other dignitaries. And I also welcome all the entire legal fraternity who have come to participate in this lecture. I am very happy that I am meeting you all again in this webinar too. Earlier in my lecture, when I was dealing with proof of bills, I referred to section 61 to 71 of the Evidence Act. Consciously, I omitted section 65A and 65B of the Evidence Act because I thought that it was not very relevant on that day, and also because of the paucity of time. Therefore, probably the organizer, Mr. Srinivasa Raghavan, has thought it fit to invite me again to cover that omitted area also. That is how now I am before you. So far as the evidence regarding electronic records are concerned, some change was made by the Information Technology Act in the year 2000. We all know very well. We have got the experience with this act, which also duly amended the Evidence Act for 20 years. But during this 20 years of experience, what we have learned is a subject that we are going to deal with today. What are all the difficulties which the judiciary has faced all along during this 20-year period is going to be the discussion today. To begin with, let me say that 65A and 65B were introduced why? What was the change made by that? And how this has worked all these years, that is for 20 years. Now, electronic record is a document and it is to be proved like any other document. Now, before going into section 65A and 65B, which were originally introduced in the year 2000, it is necessary for us to know as to how these electronic records were all admitted and dealt with by courts of law under the then existing provisions of the Evidence Act. So to have an idea about that, let us now have a quick look into sections 61 to 65. These were the original provisions with which we were all admitting and also disposing of the cases in courts. So let us see section 61 now. See, section 61 speaks of proof of contents of documents. Electronic record is undoubtedly a document. Therefore, how to prove the contents of electronic records by the then existing provisions before the introduction of 65A and 65B. Section 61 states like this: the contents of documents may be proved either by primary or by secondary evidence. So both are possible, both by way of primary evidence or by way of secondary evidence. The contents of a document could be proved. The electronic record, being a document, could be proved either by means of primary evidence as well as by means of secondary evidence. This is what the understanding of section 61. Let us now move on to section 62. 62 states primary evidence means the document itself produced for the inspection of the court. Primary evidence means the document. Please underline this word. Primary evidence means the document itself produced for the inspection of the court. So, primary evidence means there can be only one document, which is the original document, which is primary. That is what is stated in section 62. Please underline the word the document. Document means the original. Now, I do not want to read these explanations. Let me move on to, because these things I've already read during my earlier session. Therefore, let me move on to section 63. Now, secondary evidence means, so that means other than the original, other than the document, what are all the evidences which are known as secondary evidence? That is also defined in section 63. Secondary evidence means and includes certified copies given under the provisions hereinafter, copies made from the original by mechanical process, which in themselves ensure accuracy of the copy, and copies compared with such copies. Copies made from here compared with the original, from or compared with the original. Counterparts of documents as against the parties who did not execute them. Oral accounts. See, there are 5 evidences which are called as secondary evidences. These are all other than the original. Original is a document which is primary. These are all secondary evidences. There are 5 kinds of secondary evidences. Now, for the purpose of electronic records, we were using this subsection 2. Copies made from the original by mechanical process, which in themselves ensure the accuracy of the copy. What is the original? See, let us say I send one email to an X. The X receives it. Now, from out of that, he takes a copy. That copy is produced in court. The original is the information that is contained in the instrument, namely in the email, in the computer. That is the original. Any printout taken out of the same is secondary evidence. Copy made from the original or by means of mechanical process. The original is there in the computer. A copy is taken. That is, we call it as computer output. This is admittedly a secondary evidence. Secondary evidence. So a photograph is taken using the photo film. You know, in those days when we had films, the photo film is the original. That is the document. A printout made out of the same is nothing but a copy or a secondary evidence. So the photo is the secondary evidence. Photo film is the primary evidence. Similarly, the contents in the computer is the original, and a copy, a computer output taken and produced before the court is nothing but secondary evidence. This is what section 63 says. Now let us move on to section 64. Now, proof of content, documents by primary evidence. Documents must be proved by primary evidence, except in the cases referred hereinafter mentioned. Document means the word documents refers only to the original. You understand in such a way that document means it is the original. So the original document must be proved by primary evidence, that is by producing the original itself. So the contents of the document, namely the contents of the original, must be produced by producing the original itself before the court. Very good. Now, suppose a party is not in a position to produce the original for some reason or the other, then what is the remedy available for him, or opportunity available for him? That is dealt with in section 65. When the original, when the document, when the primary evidence could not be produced for the reasons stated in section 65 of the Evidence Act, we are permitted to produce the secondary evidence. The secondary evidence means the 5 kinds of evidences which are dealt with in section 63. Okay. Now, when the secondary evidence can be let in, section 65 is important for electronic records also. Cases in which secondary evidence relating to document may be given. Secondary evidence may be given of the existence, kindly underline, may be given of the existence, condition or contents of a document in the following cases. So by means of secondary evidence, you have to prove the existence of the original. First of all, the original came into being, that has to be proved. They can condition what has happened to that, what is the condition of the document, that you have to prove. Then or contents. Otherwise, the contents of the document you have to prove by means of secondary evidence. In what circumstances? They are enumerated in section 65B, 65 of the Act. So now let us move to, for the purpose of this discussion, we will move to D. 65A says when the original is shown or appears to be in the possession or power of the person against whom the document is sought to be proved. Suppose the original, namely the computer containing the original record is in the hands of the respondent. He may refuse to produce it, despite notice issued under section 66. In such an event, you can produce a copy. I give you one small illustration. You go to a person and pay rupees 10 lakhs to him. He gives a receipt that is not signed, but it is only a computer output, which does not carry the signature of the party. That is issued to you, you bring it here. Now, when the question arises before the court, as to whether you repaid that amount or 10 lakhs or not, you produce this receipt. This receipt, computer output, does not contain the signature of the person who has issued it. A defense may be taken that this has got no authenticity because it has not been signed by the person who issued it. Now, this is nothing but in electronic record, a copy of the electronic record, a secondary evidence. This can be proved by what? This can be proved by invoking this provision, namely section 65A, by issuing notice to the other party to produce the original or to admit the document. If he refuses to produce the original, then you can use this as a secondary evidence, you are permitted. Similarly, B, when the existence, condition or contents of the original have been proved to be admitted in writing by the person against whom it is proved or by his representative interest. If there is admission that this reflects the original, you can produce the secondary evidence. Then C is very important. When the original has been destroyed or lost, suppose what is recorded in the computer is destroyed, is deleted, then also the copy can be produced before the court as a secondary evidence. This also is important. Now, fourth, when the original is of such a nature as not to be easily movable, the server with the BSNL department cannot be moved, or even assuming that it is a small computer used in an office, it may contain several matters and several materials. Therefore, it cannot be moved easily to the court. In such an event also, you can lead secondary evidences. The secondary evidence can be permitted now by using section 65. Secondary evidence can be permitted to be admitted in these circumstances. This was what originally the law was. Before 2000, we were admitting photographs, we were admitting tape recorders, the tapes containing some recording of voice, etc. How? 65A and 65B were not there then. It is not as though these electronic records were invented after 2000. Even before that, electronic records were very much available. But those records were admitted either by means of producing the original, namely the primary evidence, or by means of secondary evidence by establishing the factual foundation required under section 65 of the Evidence Act. So before 2000, before the introduction of 65A and B, there were electronic records, and they were also proved before the courts of law in the absence of 65A and 65B. How? By using the existing provisions from 61 to 65. Keep this as an introduction to the subject. Now, what was the change made by 65A and 65B? By these two provisions were introduced in 2000. What were the changes made? Let us go into section 65B and 65B, A and B first. Please kindly. 65A, special provision as to evidence relating to electronic record. Special provision relating to evidence relating to electronic record. Please kindly see. Yes. So 65A, the contents of electronic records may be proved in accordance with the provisions of section 65B. The contents of electronic records may be proved in accordance with the provisions of section 65B. What is electronic record? The term electronic record has been defined in section 2T of the Information Technology Act, which says electronic record means data, record, or data generated, image, or sound recorded, received, or sent is in an electronic form, or microfilm, or computer generated microfiche. So this is the electronic record. This is the original. Just see, there are three modes. One, anything recorded, if the recorder itself is available, which contains the information which is recorded, that is an electronic record, that is primary evidence. Two, received. Suppose one email is received into your computer, then the information contained in your computer, or you receive a WhatsApp message or an SMS to your cell phone, which is stored in your cell phone. The information received into your computer, into your device, which is stored there, and therefore that is the primary evidence. Where it is stored, in the zip it is stored, that is the primary evidence in respect of an information received. So information recorded, information received or sent. Suppose you are sending one message by SMS or by WhatsApp, then your computer, your cell phone contains a record of what you have sent. So this is the primary evidence. So these three things kindly keep in your mind. One, a message which is recorded. If you record something in your computer, suppose you record some voice in your cell phone. Suppose you photograph something or videograph something which is recorded in your cell phone. That is your cell phone record is the electronic record as defined in section 2T, number 1. See, this is recording. 2, after recording, you are sending to somebody or you send some message to somebody. That what was sent to other one is also recorded in your cell phone or in your computer. So this information contained in your device is again a original document. That is an electronic record in terms of section 2T of the Act. Then third one is the information received in your device, that is stored in your device, that is also now original. This is the electronic record which is dealt with in section 65A. Now let us move on to 65A again. Please kindly come to section 65A. The contents of electronic records may be proved in accordance with the provisions of section 65B, which means what is contained in your cell phone which is recorded, or in your electronic device which is recorded, what was sent by you which has been recorded in your device, and what has been received by the other man which is contained in his device are all primary evidences, namely electronic records. They may be proved. How they may be proved? That is what section 65A says. Earlier we were using the other provisions, the sections 61 to 65 we were using to prove that. Now 65A says you can also prove it by following section 65B. You can also prove the contents of the original electronic record. Some information is there in that. How to prove? You may also prove it. You may, please underline this, you may prove it by following section 65B. Now 65B is the provision which has confused all of us almost for 20 years. Let us read section 65B as to what does it convey. Notwithstanding anything contained in this act, any information contained in an electronic record, so any information contained in the electronic record which is the original, which is the document. Document is the original. whatever is contained, whatever is the information which is contained in the electronic record, which is original, which is now printed on a paper, stored, recorded, or copied in optical or magnetic media, produced by a computer, hereinafter to as the computer output, shall be deemed to be also a document. Now, the original is there in the computer. A computer output is now taken, hereinafter referred to as the computer output. So a copy taken, a printout taken, or something recorded by copying that. These things are known as computer outputs. Computer outputs. So the computer output shall be deemed to be also a document. Which, so please kindly see, these words are very, very important. This is the change, only change in my estimation the law has made. What it has done, the computer output shall be deemed to be also a document. So how many documents are there now? Original document is the electronic record which is contained in the device. Now, a computer output is taken. Now, that computer output, namely a printout, is also elevated to the position of a document. So what was all along treated as a copy is now treated by a deemed fiction as a document. Please kindly see this, understand this. This is the whole confusion which we have got for 20 years. I want to clarify this by reading it again and again. The computer output shall be deemed to be also a document. Originally, there was a document which is contained in the device. So what is that information is to be proved? How to prove? If the original itself is produced, then there is no difficulty. When we are producing a copy, a computer output, then this is secondary evidence. Before 2000, we were using this as a secondary evidence, and by satisfying the requirements of section 65, we admitted this secondary evidence also in order to prove the contents of the original. So what is the effort? There is one original document which contains some information. What is that information? That information is to be proved. How do we prove? Yes, by producing the original. So let us take the case of a sale deed. A sale deed, a registered sale deed is the original. How to prove the contents? By producing the same before the court. What is the information that it contains? A has sold the property to B for so much of amount. Possession has been given, and this is the description of property. These are all the informations contained in the original document. This information, that sale was made, consideration was paid, possession was given, it contains a lot of informations. These informations are to be proved. How? By producing the original. That is what section 62 says. Now, when we say that original is lost, original is destroyed, we say that we can produce the secondary evidence. Secondary evidence. When we say we are now satisfying section 65B, we say the original is not lost. Then when the original is destroyed, the original is lost, how to know about the contents of that? The contents are to be proved. How to do that? Therefore, we produce a copy. We produce a copy. We ensure that this is nothing but the true copy of the original. Therefore, by proving the contents of the copy, we require the court to infer that the original also contains the very same information. It is nothing but an inference on the part of the court. I think that I have made it very clear. We are producing a copy. The copy contains the information. What is the information? Sale was made, consideration was paid, this is a property, possession was given. Where is it contained? In the copy it is contained. When we ensure that this is nothing but the copy of the original, we say that these are the contents in the original also. Therefore, ultimately what we prove? The contents in the original document. By producing a secondary evidence, we prove the contents in the original document. Okay, that you should understand very clearly. Now, before 65B, when the original, namely when the original is lost, that is an electronic record is lost, we can produce the secondary evidence. Or when the original could not be moved, we take a computer output, we produce that. We were marking, we were admitting the same in evidence. How? As secondary evidence. By producing the secondary evidence, that is a copy of the electronic record, a computer output. By producing the secondary evidence, we proved the contents of the original. For that, we had to satisfy section 65. This was the only condition. Now, 65B, now section 65B does only one thing. It says that a copy which was all along a secondary evidence is now elevated or promoted as a primary evidence. You please kindly see the language used. The computer output deemed to be also a document. So what was originally the document? The original which is contained in the device is a document. Now, yet another document is made. So by a deemed fiction, what was all along treated as secondary evidence is now promoted, now elevated, now converted as a document, which means this is also a primary evidence. This is also a primary evidence. Now there are two primary evidences. Number one is the original content in the computer. Number two is the computer output. There are now two originals. So in order to prove the contents of the first original, you can simply produce the second original, which is the computer output. Provided section 65B further says, if the conditions mentioned in these sections are satisfied. That is what we call as the 65B certificate and conditions. Now, what are the conditions which are to be satisfied? To elevate this document as a primary evidence, to elevate this copy as a document, a primary evidence, what are the conditions to be satisfied? Which are stated in 65B. Please kindly put 65B. Don't change it unless I say 65B. If the conditions mentioned in this section are satisfied in relation to the information and computer in question and shall be admissible in any proceedings without further proof or production of the original. Now, you are permitted to produce a computer output as a document, as a primary evidence. That is the magic that section 65B has done by deemed fiction. Now, what are the conditions to be satisfied? Section 2. The conditions referred to in subsection 1 in respect of a computer output shall be the following. Please kindly put section 65B on the screen. The conditions referred to in subsection 1 in respect of a computer output shall be the following, namely, the computer output containing the information was produced by the computer during the period over which the computer was used regularly. So, see, the first condition is the computer output containing the information was produced by the computer during the period over which the computer was used regularly to store or process information for the purpose of any activities regularly carried over that period by the person having lawful control over the use of the computer. This condition used to be satisfied. What is this condition? The computer was during the said period was regularly used, regularly carried on over that period by the person having lawful control over the use of the computer. Suppose you have the cell phone, you should satisfy that the cell phone was regularly used by me and there was no defect. I had the lawful custody of the same. This condition used to be satisfied by you. Now, second one, if not the first condition. Second condition, during the set period, information of the kind contained in the electronic record or of the kind from which the information so contained is derived was regularly fed into the computer in the ordinary course of the said activities. So apart from proving the first condition, you should also prove the second condition. Third condition, the information contained in the electronic record reproduces or is derived from such information fed into the computer in the ordinary course of the said activities. So these three conditions are necessarily to be proved by you to elevate the document, elevate a copy as primary evidence, to elevate a computer output as primary evidence. These three conditions are to be necessarily proved by you. These conditions are to be satisfied. Now, apart from that, now you go to section 3, where over any period, the function of storing or processing information for the purpose of any activity is regularly carried on over that period, as mentioned in clause A of subsection 2, was regularly performed by the computers, whether by a combination of several computers, etc. Let us skip. Now, go to subsection 4. In any proceeding where it is desired to give a statement in evidence by virtue of this section, a certificate doing any of the following things. That is to say, number 1, identifying the electronic record containing the statement and describing the manner in which it was produced. You have to say that this was my cell phone or this was my computer. You have to identify the computer. Then you should say that how did you take a copy of that? This is the first requirement, not condition. Second requirement, giving such particulars of any device involved in the production of that electronic record as may be appropriate for the purpose of showing that the electronic record was produced by a computer. This is production. If it is recorded, if it is produced, then you have to give a certificate. 3, dealing with any of the matters to which the condition mentioned in subsection 2 relate. Now, so far as subsection 4 is concerned, it says a certificate doing any of the following things. Any of the following things. Number 1, you may say that you may certify that first requirement is satisfied, namely identifying the electronic record containing the statement. This you can say. Second, or else, that is the reason why any of the following things. 2, giving such particulars of any device involved in the production of that electronic record. This may be given. Third, otherwise, dealing with any of the matters to which the conditions mentioned in subsection 2 relate. You may say the other 3 conditions in subsection 2 are satisfied. You can say that these requirements were maintained by me. So there has to be a certificate under section 65B. This will be a little confusing. So don't go into this very, very deeply. I will come later. Now, what is required? A certificate is required under section 65B. When such a certificate is required, subsection 4 closely watch subsection 4. In any proceeding where it is desired to give a statement in evidence, when you desire to produce a secondary evidence as primary evidence as per section 65B1, then you need to have this kind of certificate. You need to have this kind of certificate. Now, when you produce a certificate as required under subsection 4 of 65B, what do you do? When you give the certificate, then what is otherwise a secondary evidence? What is otherwise a simple output, computer output, which is secondary evidence, is now promoted as a document, promoted as primary evidence. Please kindly understand. Now, it is in this, the word used is when it is so desired. If you desire if you decide, if you want to produce this as a primary evidence, by getting it promoted as a primary evidence, then you need to produce this certificate. Please understand this. So we will quickly look into section 65(1) again, 65(b)(1). Please come to 65(b)(1) again, then come here. I'm going to read the judgments, then it will be clear. See, notwithstanding anything contained in this act, any information contained in electronic record which is printed on a paper, stored, recorded, or copied in optical or magnetic media produced by a computer, hereinafter referred to as a computer output. So, a computer output shall be deemed also to be also a document. Shall be deemed to be also a document if the conditions mentioned in this section are satisfied. Stop here. So, what does it do? A computer output, which was all along treated as a secondary evidence, gets elevated as a document, as a primary evidence. How? When you satisfy these conditions. What are those conditions? Issuing a certificate. When you add a certificate, when you want to use the computer output as a primary evidence without producing the original computer, you need to produce the certificate. By producing the certificate, what do? You elevate the document, you elevate the computer output, you promote the secondary evidence, or you convert the secondary evidence as primary evidence. This is by the deemed fiction. Please understand, shall be deemed to be also a document. Very good. Subsection 4 says, when you desire to produce in any proceedings, when it is desired to give a statement in evidence by virtue of this section. So if you want to give promotion to a computer output as a primary evidence, then and use the same as primary evidence, you have to produce a certificate. Then what is the effect? Simple understanding. If you do not produce a certificate, the computer output is not elevated as a document. It remains to be only a secondary evidence. Now, I think that you may not have any doubt now. When you desire, when you want to elevate the computer output as a document, as a primary evidence, then you need to produce a certificate. If you do not desire to give promotion to the computer output as a document, then you need not produce the certificate. If you need not produce a certificate, you will not use section 65A and 65B. Then you will go back to section 62 and 65. If section 62 could not be complied with, that is, if you are not able to produce the original, by satisfying section 65, you will produce the secondary evidence. That is what section 65B, A and B have done in the law of evidence. That is my understanding. Now, let us go into the judgments of the courts. Now, all the judgments have been circulated to you. I would like you to go to few judgments of the earliest was, so this is for your information only I am giving. The earliest judgment was reported in R versus Masood Ali, AIR 1965, All England Reporter, page 464. This judgment will find reference in all the subsequent judgments of the Supreme Court. Therefore, I am referring to that. R versus Masood Ali, 1965, All England Reporter, page 464, which was followed later in R versus Robson, 1972, to All England Reporter, 699. In these two judgments, it was said that when a tape record, even an electronic record containing the voice of an individual is produced, what is to be proved? Voice of the person must be duly identified by the maker of the record or by others who know it. Accuracy of what was actually recorded has to be proved. The probabilities of tampering should be ruled out. These two things you please kindly keep in your mind. One, accuracy. Second one is ruling out the possibility of tampering. If these two are ensured, then the documents were all admitted in England. This judgment was followed by our court in Ram Singh versus Colonel Ram Singh. Ram Singh versus Colonel Ram Singh, reported in 1985, supplement SEC, page 611. It was a 3-judge bench. There, the 3-judge bench of the Supreme Court reiterated these principles. Accuracy and the possibility of tampering should be ruled out. These are the fundamental things to prove. And so, following this Ram Singh, we were marking, we were admitting, and we were dealing with all electronic records. Then came the judgment of the Hon'ble Supreme Court in Chandu's case. Then came Chandu's case. That is, Navjot Chandu versus State of NCT, page 2005, 11 SEC, page 600. This judgment you all read. What is stated in this judgment? The Supreme Court went into section 65A and B, and the Supreme Court 2-judges bench held that section 65B and A only deal with the secondary evidence being elevated as primary evidence. They have not done away with section 62 or 65. Therefore, the party, if the certificate is not produced, then the party can prove that electronic copy, the computer output under section 65, as you are proving any other secondary evidence. This was said in Chandu's case. This was being followed. This happened in 2005. From what was the message? No certificate need be produced. If you produce the certificate, then you will prove the document as per section 65B. If you do not produce the certificate, you will prove the computer output as secondary evidence under section 65 of the Evidence Act. Please, I want to repeat for your understanding. What this court said was, if there is certificate under section 65B, then you will prove the document as required, as provided in section 65B. Okay, which means what? A computer output will be proved as a primary evidence under section 65B. If you do not produce the certificate, then you will go back to section 65 and prove the same as secondary evidence. This was what was said in Chandu's case. Then Chandu's case came up for consideration before a 3-judge bench of the Hon'ble Supreme Court in P.V. Anwar versus Bashir, 2014. So in P.V. Anwar, the Hon'ble Supreme Court took a different view. It said that section 65A and B are all special provisions, and therefore the special provision should give way for, should take precedent, overriding effect over the general provision. Therefore, the Supreme Court in this case said that section 61 to 65, more particularly section 65, stands excluded because of section 65A and section 65B. This was said in Bashir's case. You please kindly come to Bashir's case. Please kindly come to Bashir's case. That is P.V. Anwar versus Bashir.
2014 10 SEC 473.
Yes.
It is para 16. It is further clarified that the person need only to state in the certificate that the same is to be to the best of his knowledge and belief. Most importantly, such a certificate must accompany the electronic record like computer printout, compact disc, video compact disc, DCD, pen drive, etc., pertaining to which a statement is sought to be given in evidence, when the same is produced in evidence. All these safeguards are taken to ensure the source and authenticity, which are the two hallmarks pertaining to electronic record, sought to be used as evidence. Electronic records being more susceptible to tampering, alteration, transposition, excision, etc. Without such safeguards, the whole trial based on proof of electronic records
Okay.
can lead to travesty of justice.
Okay. Now, see, in an earlier paragraph, I will also read that
15.
any document, yes, any documentary evidence by way of an electronic record under the Evidence Act in view of section 5965A can be proved only in accordance with the procedure prescribed under section 65B. 65B deals with the admissibility of the electronic record. The purpose of these provisions is to sanctify secondary evidence in electronic form generated by a computer. It may be noted that the section starts with a non-obstant clause. Thus, notwithstanding anything contained in the Evidence Act, any information contained in an electronic record which is printed on a paper, stored, recorded, etc., shall be deemed to be a document only if the condition mentioned in under subsection 2 are satisfied without further proof or production of the original. The very admissibility of such a document, that is electronic record, which is called as a computer output, depends on the satisfaction of the four conditions under section 65B. So in this case, the Hon'ble Supreme Court said, the three-judge bench of the Hon'ble Supreme Court said that unless there is a certificate, the document is not at all admissible in evidence. The computer output is not at all admissible in evidence. The computer output is not at all admissible in evidence. I throw a question to you now. Now, you travel in a flight. For that, you are given a ticket. You travel in a train. For that, you are given a ticket. So, a boarding pass or a ticket, which does not contain the signature of anyone. It does not contain the signature of anyone. If you want to prove that document before the court, then who will give certificate for that? Who will give certificate? It is an electronic record. It is a computer output taken from the electronic record. The original is with the railways. The original is with the airliner. How will you prove this document if you do not have the certificate? The full bench says, three-judge bench says that section 65B, unless you have the certificate, computer output is not at all admissible in evidence. How can this be? This bench, in my considered view, has omitted to look into, with great respect, the language of 65B1. As I already pointed out to you, if you want to use a secondary evidence as primary evidence, if you want to use a computer output as a document, then you have to produce the certificate so as to prove the case by producing this as a primary evidence. Suppose you do not have the certificate, what the document will remain only as a secondary evidence. As secondary evidence, it can be used under section 65B. The contradiction in the judgment is that at one place it says that the computer output cannot be admitted in evidence unless there is certificate. Now I will read the portion again. Any documentary evidence by way of an electronic record under the Evidence Act in view of section 5965A can be proved only in accordance with the procedure prescribed under section 65B. So if you do not have the certificate, according to this bench, it cannot be proved at all. It cannot be produced in court at all. It has lost its evidentiary value. How can this be? This is my very great doubt, with due respect. A secondary evidence, which was all along being admitted as secondary evidence, now which gets elevated, which gets promoted as primary evidence because of the certificate, is admitted as primary evidence. If there is no promotion, then it will remain as secondary evidence. Then in the event you satisfy section 65, you can prove the same as secondary evidence. Where is the indication in the Evidence Act to say that a computer output can be proved only as primary evidence? Where is it stated? Section 65B does not say that a computer output shall always be proved only as a primary evidence. Section 65B says it is document is, then the computer output becomes a document. A secondary evidence becomes a primary evidence. Subsection 4 says if you desire to use the same as a primary evidence, produce a certificate. I may say, I do not want to elevate this because I am not able to produce a certificate. Okay, I do not desire to use the same as primary evidence because I do not have the certificate. Okay, what is the effect? I have the secondary evidence. This is secondary evidence. The nature of the document, the evidentiary value of the document will never be lost. This is to be admitted as secondary evidence. This was what was said in Chandu's case. But now in this case, the Honorable Supreme Court, the 3-judge bench, has taken a different view and has overruled Chandu's case. Now, as per this case, the computer output cannot be produced in evidence unless there is a certificate under section 65B, which means this has got no evidentiary value at all. It is totally inadmissible, complete ban to prove the same in the absence of a certificate. I got my own doubts about the correctness of the view taken by the Honorable Supreme Court in this case. The Evidence Act does not say that the secondary evidence will lose its evidentiary value or admissibility. It can certainly be proved as secondary evidence. This is my humble view. Now, it is further clarified that the person need only to state in the certificate that the same is to the best of his knowledge and belief. Most importantly, such a certificate must accompany the electronic record like computer printout, computer compact disc, video compact disc, pen drive, etc., pertaining to which a statement sought to be given in evidence when the same is produced in evidence. All these safeguards are taken to ensure the source and authenticity, which are the two hallmarks pertaining to electronic record, sought to be used as evidence. The electronic record being more susceptible to tampering, alteration, transposition, excision, etc. Without such safeguards, the whole trial based on proof of electronic record can lead to travesty of justice. Only if the electronic record is duly produced in terms of section 65B of the Evidence Act, the question would arise as to the genuineness thereof, and in that situation, resort can be made to section 45A of the Evidence Act. The Evidence Act does not contemplate or permit the proof of the electronic record by oral evidence if requirements under section 65B of the Evidence Act are not complied with, as the law now stands in India. Then it goes on, and in another area, paragraph 16, the proof of electronic record is a special provision introduced by the IT Act, amending various provisions of the Evidence Act. The very caption of section 65A of the Electronic Evidence Act, read with section 59 and 65B, is sufficient to hold that the special provision on evidence relating to the electronic record shall be governed by the procedure prescribed in section 65B of the Evidence Act. This is a complete code in itself. This is a complete code in itself. Please underline this. This is a complete code in itself. Being a special law, the general law under section 63 and 65 has to yield. This is a complete code. Okay, this observation, in my view, is correct to some extent. See, this is a complete code when you want to use a secondary evidence as primary evidence. If you want to use a secondary evidence by promoting the same as primary evidence, that is by satisfying the requirements of section 65B, then this is the complete code. This is not a complete code in respect of secondary evidence. The second part, Being a special law, the general law under section 63 and 65 has to yield. This, in my humble view, with a great respect to the Honorable Supreme Court, may not be correct. The reason is this. It is, as I already stated, it is a complete code in itself when the secondary evidence is sought to be proved as primary evidence by elevating the same, by promoting the same, by producing the certificate. To that extent, it is a complete code. This is not a complete code in respect of a secondary evidence. Now, having said this, it may be seen that it was a case where a responsible official had duly certified the document at the time of production itself. The signature in the certificate were also identified. That is apparently in compliance section 65B of the Evidence Act. However, it was held that irrespective of the compliance with the requirement of section 65B, which is a special provision dealing with admissibility of the electronic record, there is no bar in adducing secondary evidence under section 63 and 65 of an electronic record. This was what was said in Chandu's case. In Chandu's case, they said that section 63 and 65 are very much available. If you are not to elevate, if you are not able to promote the secondary evidence as primary evidence, you can very well go to section 63 and 65. This is overruled. Now move to 22. Please kindly move to the evidence relating to the electronic record as noted herein before. Being a special provision, the general law on secondary evidence under section 63 reduced section 65 of the Evidence Act shall yield to the same. Generally, a special bus non-derogatory. Special law will always prevail over the general law. It appears the court omitted to take note of section 59 and 65A dealing with the admissibility of electronic record. Section 63 and 65 have no application in the case of a secondary evidence by way of electronic record. The same is wholly governed by section 65A and 65B. To that extent, the statement of law on admissibility of secondary evidence pertaining to electronic record as stated by this court in Navjot Singh Chandu's case does not lay down the correct legal position. It requires to be overruled, and we do so. An electronic record by way of secondary evidence shall not be admitted in evidence unless the requirements under section 65B are satisfied. Thus, in the case of CD, VCD, chip, etc., the same shall be accompanied by the certificate in terms of section 65B obtained at the time of taking the document, without which the secondary evidence pertaining to that electronic record is inadmissible. So what they conclude, secondary evidences cannot be admitted by invoking section 63 and 65 of the Evidence Act at all. The only way is get a certificate, produce the document as a primary evidence. Then only it is admissible. If you do not have the certificate, you have got no other way to prove that. That is what is stated. See, you go to a person, in the illustration which I gave just now, you go to a person, you pay money. He receives the money, gives a computer generated bill. There is no signature, nothing. You are bringing the same. How to give? You have to produce the same. You need certificate. The computer is in the hands of the respondent. He will not give the certificate. Can you demand him to give certificate? Even if you demand, would he give? He will say to his best of his knowledge that the computer was properly functioning. It was put into use in the regular course of business and all that. He will say, assuming that he is compelled to give a certificate, that he will say that to my best of knowledge, I cannot say whether the computer was properly functioning without any interruption. How can you expect this man to give a certificate out of his knowledge? He may say, even genuinely he may say that my knowledge is different. I do not have knowledge. How can you compel him to give a certificate? If the certificate is not available, as per this judgment, the receipt, the computer bill which you have cannot be produced in court in evidence. As a result, what happens? You will have only oral evidence to say that I paid that amount on so and so date. That oral evidence is not admissible because it speaks of the contents of a document. The contents of the original. Original is not produced. Then what will happen? You are losing a case. Therefore, there has to be way out for this. That is the reason why I say that the language that in section 65B1 should be carefully analyzed, understood. It says the computer output shall be deemed also as a document. What was already not a document, what was already only as a secondary evidence, now because of the certificate becomes a document, becomes a primary evidence. This is the only magic that section 65B1 has done. Without looking into this properly, without understanding this properly, now in my humble view, that we have been trying to interpret. And that is the reason why in this judgment, I got with great respect some disagreement. They say section, if you do not have the certificate, this is nothing but a piece of paper having no value at all, throw it out. How? This is the only authority I have. This is the only evidence I have in my hand, which I want to produce before the court. You are shutting me out. So to that extent, this, they say, this judgment, in my considered view, requires reconsideration. It says section 63 and 65 are not applicable in respect of computer outputs. So section 65A and B have made section 63 and 65 inapplicable to a computer output. This, in my humble view, requires reconsideration. Now, having said this, the Honorable Supreme Court, it is further clarified that the person need only to state, no, not this. It is clarified that notwithstanding what we have stated above, it is clarified. See, please kindly recollect. In earlier paragraph, it has been said that if you want to produce the computer output, you need certificate. If you don't have certificate, you have no case, you cannot use it for any purpose. You cannot admit the same. That is what was stated in the earlier paragraphs. Now here they clarified. It is clarified, now notwithstanding what we have stated herein in the preceding paragraphs on the secondary evidence on the electronic record, with reference to section 59, 65A and 65B of the Evidence Act, it is an electron, if an electronic record as such is used as primary evidence under section 62 of the Evidence Act, the same is admissible in evidence without compliance of the conditions in section 65B of the Evidence Act. You see, I apprehend that there is some contradiction in the judgment. Why 65A and 65B certificate is required? In order to ensure, that is the observation made, that there is no alteration, that it is regularly used, there is no tampering, in order to ensure the authenticity and the integrity of the document. These are the two things. In order to ensure the accuracy and to rule out the possibility of tampering. For that purpose, you need section 65B certificate. Very good. Now here they clarify that if the original itself is produced, then no such a certificate is required. Well and good. When the original itself is produced, section 65B certificate is not required. I'll read that. It is clarified that notwithstanding what we have stated herein in the preceding paragraphs on the secondary evidence on the electronic record with reference to section 59, 65A and 65B of the Evidence Act, if an electronic record as such is used as primary evidence, under section 62 of the Evidence Act, the same is admissible in evidence without compliance of the conditions of section 65B of the Evidence Act. So if the original is produced, then 65B need not be complied with. Can you say that in the original, tampering is not possible? Original can also be tampered with. It can also be modified. So when the original requires no certificate, then why the secondary evidence requires certificate? Secondary evidence, so according to them, 65B certificate is required because to rule out the possibility of tampering, modification, etc., to ensure the accuracy, to ensure the integrity of the document. You need certificate under section 65B. when it comes to the original, comes to the case of original, is it not possible to have such kind of modification, tampering, etc.? So at any rate, the section, when you say that section 62 is applicable, please kindly see. Section 62 of the Evidence Act is applicable, under which the original can be produced as a primary evidence. Very good. I got no quarrel over this issue at all. When the original is produced, you are proving the same under section 62. That is by producing the original. Very good. Very good. Now, under section 65B1, the secondary evidence is now promoted as primary evidence, and that primary evidence is admissible under section 62 again. If you do not have the certificate, that is what section 65B1 says. It speaks of admissibility. Admissibility as primary evidence. But I think that this has been misunderstood to say that it speaks of very admissibility itself. My humble view is section 65B1 speaks only of admissibility as primary evidence, not its very admissibility itself. Okay. To that extent, this judgment, in my humble view, requires some reconsideration. To put it in nutshell, 65B1 elevates a secondary evidence as primary evidence, and when you produce that as primary evidence, you do it under section 62, therefore it is admissible. So in essence, if there is certificate, you prove the same under section 62 as primary evidence. If there is no certificate, you have to prove the same under section 65 as secondary evidence. This is my humble view. I throw it open for you to consider. All right. Now, between 2005 to 2014, what happened in this country? Because in Chandu's case, the Supreme Court said, two judges said that if there is no certificate, still it is admissible as secondary evidence. In many cases, hundreds and hundreds of cases, these certificates were not at all produced, because the legal fraternity were hopeful that these documents can be produced in evidence as secondary evidence. They are all admissible. So by satisfying section 65, for about 9 years in this country, all these electronic outputs were all admitted as secondary evidence, and courts were giving judgments. Now suddenly came, after 9 years, the 3-judge bench in this Hon'ble case. What Hon'ble did? Chandu is overruled. It was not even a prospective overruling. So what would have happened to hundreds and hundreds of cases where these secondary evidences were all admitted between 2009 to 2014? In one such case, which I can say now, which I dealt with, in myself and another honorable judge in a division bench. See what happened in that case. There were multiple accused. A1 gave instruction to A2 from her cell phone to his cell phone. That information was to do away with somebody, to kill some person. This information was recorded in the cell phone of A2. For his safety, he recorded whatever was instructed by A1, he simply recorded the same in his cell phone. Now his cell phone SIP is the primary evidence. Very good. Now what does he do? He took the same to a computer center, gave the same to him, and got it downloaded in a computer disk CD. You know what happened? Using a computer, this was downloaded and a copy was taken in by way of CD. So A2 was now having CD. Now A1's cell phone was destroyed. A2's cell phone was also destroyed. During investigations, come to light that these things were not available. Now what was available? The CD alone was seized by the police. It was produced before the court. Now, following Chandu's case, the trial court admitted the CD as secondary evidence. The trial court, relying on the same, convicted the first accused for conspiracy because what was contained in the CD, that information was sufficient to invoke Section 10 of the Evidence Act and to convict A1 under Section 120B. There were small other evidence, let us not worry about that. Now, when the appeal came before us, this P.V. Anwar case had come. As per P.V. Anwar case, this cannot be admitted either as primary evidence or as secondary evidence. So, in effect, this is to be simply thrown out. Because of this judgment, we had to reject that CD. Otherwise, the CD contained lot of information making out a very strong case against A1 also. But because the CD had to be rejected, since in Anwar case, the Supreme Court has said that this cannot be admitted even as secondary evidence, we had to reject and we got acute the first accused. You see what happened because of the sudden shift in the law. The Supreme Court did not think it necessary to declare this overruling as a prospective overruling. You all know that there is a concept known as prospective overruling, by which the Supreme Court alone has got the power to declare its judgment only to have prospective effect. That this judgment was not declared as a prospective overruling. As a result, this had a retrospective application, and so several hundreds of cases were to be decided otherwise by rejecting this secondary evidence, namely the computer outputs. So this was the result of this case. Then immediately within 3 years, so this was the law from 2005 to 2014, 9 years. Now from 2014 to 2017 came Sonu's case. Again, the same issue, whether it can be admitted in the absence of certificate under Section 65B came up. This was a 2-judge bench. Therefore, they could not express any view against the 3-judge bench. This bench, however, lamented. This bench said, no, the 3-judge bench would have very well said that this is a prospective overruling applicable only for future cases, and this will not have retrospective operation. But the 3-judge bench did not say so. As a result, lot of problems have come. This court did not apply the principle of prospective overruling in Anwar case. The dilemma is whether we should, this court in so-and-so case, held that an earlier judgment would be prospective, taking note of the ramifications of its retrospective operation. If the judgment in the case of Anwar is applied retrospectively, it would result in unscrambling past transactions and adversely affecting the administration of justice. As Anwar's case was decided by a 3-judge bench, propriety demand that we refrain from declaring that the judgment would be prospective in operation. We leave it open to be decided in an appropriate case by a 3-judge bench. So, till today, Anwar case has not been declared as prospective. There was no other 3-judge bench was constituted to declare the same as prospective. So as a result, what is happening? Anwar case has got retrospective operation. All the cases where these computer outputs were admitted as secondary evidence for 9 years have suffered a lot because of this. Now, in Sonu's case, the division bench, 2 judges bench, took a different dimension. They agreed with Anwar. They said, yes, as per Anwar, because they cannot dissent from Anwar. They followed Anwar. They said, yes, of course, in Anwar case, this court has held that without the certificate, the document cannot be admitted. Very good. This court, however, said that objection in respect of admission used to be raised at the time when the document is tendered for admission. Which means the adverse party should have objected that there is no certificate, therefore don't admit. If such an objection had been raised, then only you can say that the document is inadmissible. Because the court said that this is only a curable defect. This is only curable defect relating to procedure. Had there been objection raised by the adverse party that there is no certificate, therefore don't admit this as per Anwar case, then only then the other party would have cured the same by getting a certificate and produce it. When there is no objection raised, at the time when the document is produced, when the document is tendered for admission, then the admission is not illegal. It is not open for the party at a later stage to raise objection. The court said that section 65A and 65B are all about only mode of proof, not about admissibility. This judgment, also in my humble view, may not be correct because the section itself, 65B1 itself says admissibility. So section 65B1 relates only to admissibility, not about mode of proof. You know the difference. If a document is per se inadmissible, then no objection need be raised by the party because it is not at all admissible. Take for the case of, for example, the statement recorded under section 161 CRPC, or the confession made to the police hit by section 25 of the Evidence Act. When it is tendered in evidence, no objection need be raised by the accused. If it is admitted in evidence wrongly, it can always be eschewed because per se it is inadmissible. Per se it is inadmissible. If the document is otherwise admissible, but the mode of proof is not followed, then at that stage, an objection is to be raised. If objection is not raised, then it amounts to admission of its mode. Applying this principle, the court said that section 65A and B are all about only mode of proof, not about its admissibility, and therefore, when a computer output, namely secondary evidence, is tendered in evidence, objection should have been raised regarding its admissibility. If no objection had been raised, then admission of the document is perfect and no such plea can be taken later on that the document has been wrongly admitted. This was the view taken in the judgment. Now, this judgment also creates some confusion, in my humble view, with great respect. Anwar case says that the document is admissible. Anwar case does not say that section 65A and 65B relates to mode of proof. We already read from paragraph 16 onwards in Anwar case. What they say? It is admissible provided there is a certificate. If not admissible, if there is no certificate. So per se inadmissible according to Anwar's case. It is per se inadmissible. If it is not per se inadmissible, as I have been saying, it is admissible as secondary evidence. It is otherwise admissible under section 65 of the Evidence Act. Now, court says in Anwar case, 65 is excluded. The document is per se inadmissible because there is no certificate. So this view in Sonu's case, in my humble view, is contrary to the view taken in Anwar's case in two angles. Number one, the court said in Sonu's case that it relates to mode of proof and not related to admissibility. This, in my humble view, with great respect, is contrary to the view taken in Anwar's case. In Anwar's case, the court has said that it is per se inadmissible if there is no certificate. This is the first contradiction. Secondly, the court said that if there is objection raised at the time when the document is sought to be admitted, then only it is inadmissible. My humble view is that when you say that the document is per se inadmissible as per Anwar's case, then the document requires no objection being raised at the time when it is sought to be tendered. Now, Sonu's case is correct in one way. If you hold that the document is not per se inadmissible, then the objection should have been raised. Regarding that, I got no difficulty. Whether the document is per se inadmissible, whether an output is per se inadmissible is the question. Chandu's case said it is not per se inadmissible, it is secondary evidence. Anwar said no, it is per se inadmissible because certificate is required. Now, the view taken in Sonu's case that the document is not per se inadmissible is correct. That view should have been taken. If that view is taken, then Chandu's view is correct. This can be admitted as secondary evidence. Anwar case is by 3-judge bench. Therefore, this bench in Sonu's case was not able to say contrary to Anwar's case. So the view taken in Anwar's case that it is per se inadmissible, in my humble view, requires reconsideration. So therefore, what was the law? Chandu, no certificate is required, admitted as second evidence, 9 years. Anwar, no certificate, inadmissible. Okay. This was in 2014, 3 years then. 2017, Sonu said, no. Even if there is no certificate, if there was no objection raised, it is admissible. So after 3 years, this new trend was set by the Hon'ble Supreme Court in Sonu's case. This was in 2017. Hardly within 1 year came Safi Mohammed. Hardly within 1 year. In 2018, 2 SEC, page 801. Order dated 31/2018, the case is still pending for some other reason. You please come to paragraph 7, 8 and 9 in this case, Safi Mohammed. How this has changed. Please, Safi Mohammed, paragraph 7, 8 and 9. In Anwar, I wanted you to take note. Section 65A and 65B are complete code. Where was it said? In Anwar's case. How many judges? 3 honorable judges. They said it is a complete code and therefore you can prove it only by following 65B by producing certificate. Now 2-judge bench. Section 65A and Section 65B of the Evidence Act cannot be held to be a complete code on the subject. Is it not a contrary view taken against the 3-judge bench judgment? I read Section 3. If you want, I will again go back to that Anwar's case, paragraph 17, where I read that Section 65B is a complete code. Here, this bench says 65A and 65B of the Evidence Act cannot be held to be a complete code on the subject. In Anwar PV, this court in paragraph 24 clarified that primary evidence of electronic record was not covered under Section 65A and 65B of the Evidence Act. Primary evidence is the document produced before the court, and the expression document is defined in Section 3 of the Evidence Act to mean any matter expressed, etc., etc.
Yes.
Though in view of 3-judge bench judgments in Tommaso Bruno and Ramsey Supra, Tommaso Bruno was authored by Honorable Justice Bhanumati, and where she says that we cannot afford to lose the importance of the electronic evidences because we have to run along with the current of the information technology. So it can be safely held that the electronic evidence is admissible and provisions under Section 65A and 65B of the Evidence Act are by way of a clarification and are all procedural provisions. If the electronic evidence is authentic and relevant, the same can certainly be admitted subject to the court being satisfied about its authenticity, and the procedure for its admissibility may depend on fact situation, such as whether the person producing such evidence is in a position to furnish certificate under Section 65BH. Then Section 65A and 65B of the Evidence Act cannot be held to be a complete code on the subject. In Anwar P, this court in paragraph 24 clarified that primary evidence of electronic record was not covered under Section 65A and 65B of the Evidence Act. Primary evidence is the document produced. This is what I have been trying to say by reading Section 65B. Primary evidence is the document. Section 65B, one says by deemed fiction, it becomes a document. Primary evidence, I quote this. primary evidence is the document produced before the court, and the expression document is defined in section 3 of the Evidence Act to mean any matter expressed or described upon any substance by means of letters, figures, etc., for the purpose of recording the matter. Now move on. Paragraph 12. The term electronic record is defined in section 2T. Paragraph 13, expression data, then move. Paragraph 14. The applicability of procedural requirement under section 65B4 of the Evidence Act of furnishing certificate used to be applied only when such electronic evidence is produced by a person who is in position to produce such a certificate, being in control of the said device and not of the opposite party. In a case where electronic evidence is produced by a party who is not in possession of a device, applicability of section 63 and 65 of the Evidence Act cannot be held to be excluded. See, this is what I have been saying all along. My view is that section 65B and 65A have not excluded 63 and 65 under all circumstances. This is what I have been saying all along. I have been trying to impress upon you as my view. My view is fortified by this bench judgment. In a case where, I quote in paragraph 14, in a case where electronic evidence is produced by a party who is not in possession of a device, applicability of section 63 and 65 of the Evidence Act cannot be held to be excluded. In such a case, procedure under the said sections can certainly be invoked. So if a certificate could not be produced for any reason whatsoever, then section 63 and 65 cannot be held to be excluded. This is what I have been saying. What I told a little before, when I want to use the same as primary evidence, subsection 4 of section 65B, when it is desired to produce, when I want to use the same as primary evidence, then I need certificate. If I do not have that certificate, you cannot prevent me to resort to section 63 and 65 and to use the same as secondary evidence. Here, my view is justified. You just see here, in a case where electronic evidence is produced by a party who is not in possession of a device, not only, my view is not only in possession of the device, who doesn't want the same to be proved as primary evidence. Applicability of section 63 and 65 of the Evidence Act cannot be held to be excluded. In such a case, procedure under the said sections can certainly be invoked. That is, section 63 and 65 can be invoked. I can produce secondary evidence. I can produce the computer output as a secondary evidence. If this is not so permitted, you just see this anguish expressed by this bench. If this is not so permitted, it will be denial of justice to the person who is in possession of authentic evidence, but on account of manner of proving, such a document is kept out of consideration by the court in the absence of certificate under section 65B4 of the Evidence Act, which party producing cannot possibly secure. Which party producing cannot possibly secure. Thus, requirement of certificate under section 65B H is not always mandatory. If this is not always mandatory, then I got the option. If I got the certificate, I will get the secondary evidence elevated as primary evidence. Then when it is elevated as primary evidence, it is admissible under section 62 as well as under section 65B1. I need not satisfy section 65. Straight away, without a certificate, if I want to produce the secondary evidence, I have to satisfy the requirements of section 65. If I convert the secondary evidence as primary evidence, then I need not comply with section 65 because under section 62, I am producing the primary evidence. 65 will not come in my way. But where I do not have the certificate, then as a result, I am not elevate the document as the the computer output as a primary evidence, I have to comply with section 65. This is a small thing which requires deep consideration by all of us. Then, thus, the requirement of certificate under section 65BH is not always mandatory. But 3 judgment says, under all circumstances, you have to produce the certificate. If the certificate is not there, go to hell. You got no option. Throw the document out. That was 3 judgments. 2 judgments says that it is not mandatory. Then which law is to be followed by us now? Now, let us move on to paragraph 15 again. Accordingly, we clarify the legal position on the subject on the admissibility of the electronic record. Here again, they speak of admissibility. In Sonu's case, as I already pointed out, they say it is mode of proof and not admissibility. This view is contrary to Sonu's view again. In Sonu case, the division by 2 judges said that section 65A and 65B are all about mode of proof, not about its admissibility. This is the language used in Sonu's case. This view is quite contrary to that. Quite contrary to that. Accordingly, we clarify the legal position on the subject on the admissibility of the electronic evidence, especially by a party who is not in a possession of device from which the document is produced. Such party cannot be required to produce certificate under section 65B(4) of the Act. The applicability of requirement of certificate being procedural can be relaxed by the court whenever interest of justice so requires. Now, in the previous paragraph, thus the requirement of certificate under section 65BH is not always mandatory. Then in the very same paragraph, the court also says that it is regarding admissibility. Come to paragraph 14 again. Paragraph 15, opening, accordingly, we clarify the legal position on the subject on the admissibility. Sonu's case says no, section 65A and B, mode of proof not about admissibility. This is a conflict between these 2 judgments. Now it proceeds further to say that it is not at all mandatory. This is contrary to 3 judgments. Here it further says that section 65A and B are not complete code. This is straight away in conflict with the view taken by 3 judgments, which said that section 65A and 65B are complete code by itself. That also I read, I wanted you to note down. So this is the position in Safi Mohammed. Now, after 2018, what is the position? One can say that I am not in a position to produce a certificate because the person who has got that refuses, original document, refuses to give certificate. I do not have the original, therefore I cannot give certificate. If I have the document, I have the computer from which output is taken, I can give my own certificate, self-certificate can be given. Now I am not in a position to give certificate because the document, the original is with someone else, the device is with someone else. He refuses to give certificate. Therefore, this court said, no problem. You can produce this as secondary evidence. By invoking section 63 and 65, you can use the same as secondary evidence. Now, what was closed by 3 judgments has been now opened. 3 judgments said, no, 63 and 65, not applicable. Don't use that. Now, this court has opened. This division is open. No, it is admissible. In these circumstances, you can go to 63 and 65 because 63 and 65 have not been excluded by 65A and B. So this is apparently a conflicting view. Then came after this, Safi Mohammed came this Arjun Pandita Rao versus Kailash Bhushan Rao. Here Justice Bhushan and Justice Naveen Shinga, they found, sir, go to the Supreme Court. The number is 20825 of 2017, order dated 26/7/2019. So a division bench now considered all the judgments. Yes, 26/7 order dated. Who that? This judgment is very interesting. This is a referral order. In Anwar PV and PK Bashir and others, a 3-judge bench of this court held. It is further clarified that the person need only to state in the certificate that the same is to be best signature not verified with knowledge and belief. Most importantly, such digitally signed by see here, in Hon'ble case, what was said? They extracted. That is a complete code in itself. Being a special law, the general law under section 63 and 65 has to yield. This was what was said in Hon'ble. The electronic record shall be governed by the procedure prescribed in section 65B of the Evidence Act. This is a complete code in itself. This is Hon'ble 3-judge bench. Then move further. An electronic record by way of secondary evidence shall not be admitted in evidence unless the requirements of section 65B are satisfied. Thus, in the case of CD, so and so, at the time of taking the document, without which the secondary evidence pertaining to that electronic record is inadmissible. Now, in Safi Mohammed, they extract para 20. An apprehension was expressed on the question of applicability of conditions under section 65B4 of the Evidence Act to the effect that if a statement was given in evidence, a certificate was in the paragraph 20, last 5 lines. It was submitted that section 65B of the Evidence Act was procedural provision to prove relevant admissible evidence and was intended to supplement the law on the point by declaring that any information in the electronic record covered by the said provision was to be deemed to be a document, Please kindly consider this is what I have been trying to impress upon you. Deemed to be a document and admissible in any proceeding without further proof of the original. Please kindly see. This is stated. This provision could not be read in derogation of the existing law on admissibility of electronic evidence. What is the existing law? The existing law is 63 and 65. So far as secondary evidence. So far as primary evidence is concerned, it is 62. We may, however, also refer to the judgment of this court in P.V. Anwar Bashir delivered by a 3-judge bench. In the said judgment, in paragraph 24, it was observed that the electronic evidence by way of primary evidence was covered by section 62 of the Evidence Act, to which procedure of section 65B of the Evidence Act was not applicable. However, for the secondary evidence, procedure of section 65B of the Evidence Act was required to be followed, and a contrary view taken in Navjot Singh Chandu that secondary evidence of the electronic evidence could be covered under section 63 and 65 of the Evidence Act was not correct. There are, however, observations paragraph 14 to the effect that the electronic record can be proved only as per section 65B of the Evidence Act. What Anwar missed to note is that the document is elevated as a primary evidence. It no more remains as a secondary evidence. This aspect has been missed in Anwar's case. You can kindly see in paragraph 24, last 5 lines. However, for the secondary evidence, procedure of section 65B of the Evidence Act is required. Now, if section 65B is followed, then it becomes primary evidence. It is elevated. It is also deemed to be a document. This deeming fiction as enshrined in section 65B1 has been omitted to be taken note in Anwar. So Anwar missed an important point on this. It says that is reflected in paragraph 24. However, for the secondary evidence, procedure of section 65B of the Evidence Act was required to be followed. So Anwar says, if you produce the certificate, you prove this as a secondary evidence. This reflects that the fiction, the deeming fiction found in section 65B1 has been missed to be taken note of. Now, let us move on further. There are, however, observations in paragraph 14 to the effect that the electronic record can be proved only as per section 65B of the Evidence Act. Now, section 65, paragraph 25. Though in view of the 3 bench judgments in Thomso, Bruno, and Ram Singh, it can be safely held that the electronic evidence is admissible, and the provisions under section 65A and 65B of the Evidence Act are by way of clarification and are procedural provisions. If the electronic evidence is authentic and relevant, the same can certainly be admitted, subject to the court being satisfied about its authenticity and procedure for its admissibility. This is what I say. I fully agree with Safi Muhammad. Safi Muhammad says, subject to the court being satisfied about its authenticity and the procedure for admissibility. If authenticity is a matter to be looked into at the time when it is appreciated, it falls within the domain of appreciation. Now we are at the threshold, namely at the stage of admissibility. Now this judgment says that procedure for its admissibility may depend on fact situation such as whether the person producing such evidence is in a position to furnish and certificate under section 65B. I fully agree with this view, because if I am not in a position to produce a certificate for whatever reason that may be, then my chance to prove the authenticity of the document and the contents of the document cannot be deprived of. I should be allowed to prove the document as a secondary evidence by complying with section 63 and 65 of the Evidence Act. This is what is reiterated in Safi Muhammad. Section 65A and 65B of the Evidence Act cannot be held to be complete code on the subject. In P.V. Anwar, this court in paragraph 24 clarified that primary evidence of electronic record was not covered under section 65A and 65B of the Evidence Act. Primary evidence is the document. This is what, from my word one till this moment, I have been saying. Primary evidence is the document. Section 65B1 says that it becomes a document produced before the court, and the expression document is defined in section 3 of the Evidence Act to mean any matter expressed or described upon any substance by means of letters, figures, or marks, or by more than one of those means intended to be used, or which may be used for the purpose of recording that matter. Then paragraph 29 of Safi Muhammad is extracted. Yes. The applicability of procedural requirement under section 65B of the Evidence Act of furnishing certificate used to be applied only when such electronic evidence is produced by a person who is in a position to produce a certificate, being in control of the said device and not of the opposite party. So when I am in a position to produce a certificate, by producing that certificate, I will elevate the secondary evidence as primary evidence. Now, when I am not in a position to produce certificate, don't shut me out. That is stated in Safi Muhammad, who is in a position, not of the person, who is in a position to produce a certificate, being in control of the said device and not of the opposite party. In a case where the electronic device is produced by a party who is not in possession of a device, applicability of section 63 and 65 of the Evidence Act cannot be held to be excluded. In such a case, procedure under the said sections can certainly be invoked. So section 63 and 65 can be invoked. Now move on to paragraph 3 of this Arjun Pandit Rao. Yes, we are of the considered opinion that in view of Anwar P.V. Supra, the pronouncement of this court in Safi Muhammad needs reconsideration. With the passage of time, reliance on electronic record during investigation is bound to increase. The law therefore needs to be laid down in this regard with certainty. We therefore consider it appropriate to a larger bench, rightly. Now, larger bench has heard the matter on 10/3/2020. The matter was reserved for orders. Judgment is yet to come. Now, what are the confusions we have? By way of concluding remarks, I want to say all these things to summarize as to what we have discussed. Before 2000, when 65A and 65B were introduced, electronic outputs, namely computer outputs, which were secondary evidences, were all admitted by invoking section 63 and 65 of the Evidence Act. Originals were produced or proved under section 62 of the Evidence Act. So both the original as primary evidence and the outputs as secondary evidence were all admitted until 2000 without any problem at all in this country. Now, in order to secure the authenticity and integrity of the document with good intention, 65A and 65B were introduced. The Parliament took note of the difficulties faced by the parties to produce the original. Therefore, in my view, the Parliament thought of elevating the secondary evidence as primary evidence. That is why in section 65B1, they said computer output shall also be deemed to be a document, which means shall become yet another document, shall become primary evidence. When the conditions in subsection 2 and 4 are satisfied by production of a certificate. If a certificate is produced, the secondary evidence is elevated as primary evidence, and if it is so elevated as primary evidence, I need not go to section 63 and 65. I can prove the same as primary evidence. This was what was changed by the introduction of section 65A and 65B. In my humble view, in Chandu's case, the Hon'ble Supreme Court took the correct view, stating that in the absence of certificate, the document is admissible as secondary evidence. In Sonu's case also, the division bench, two-judge bench has said that the document is not per se inadmissible, which means what? It is admissible as per the provisions of the other provisions of the Evidence Act. So therefore, Chandu's view and Sonu's view to some extent go together, which means the computer output can be admitted as secondary evidence by invoking section 63 and 65B, 65 of the Evidence Act. Then came this Anwar case after 9 years. In Anwar case, the three-judge bench said, no, this is a special provision. This is a code by itself. 65A and 65B are complete code. They exclude section 63 and 65. So under no circumstance you can invoke section 63 and 65, which means unless there is certificate, you cannot prove a computer output at all as evidence. The computer output being secondary evidence otherwise has lost its evidentiary value because 63 and 65 have been made inapplicable. So after 9 years of Chandu, this judgment came overruling Chandu. After P.B. Anwar came this Sonu. In Sonu's case, totally a different dimension was taken by two-judge bench. In Sonu's case, the two-judge bench said, no, the document is not per se inadmissible. This is in a way contrary to the P.B. Anwar. P.B. Anwar, I already told you that in P.B. Anwar, unless the certificate is there, no admission at all. Therefore, it is per se inadmissible. But in Sonu, a slight contrary view was taken. The document is not per se inadmissible. It is admissible. But if you want to admit the same, 65B certificate is required, which means, according to this bench, it does not relate to admissibility. Section 65A and 65B speak of mode of proof, not admissibility. This is again contrary to the view taken in Anwar's case. Now, source declaring, in Sonu's case, the Hon'ble Supreme Court said that because it relates to mode of proof, objection should have been raised at the time when the document is tendered for admission. If no objection was raised, then you cannot raise the objection later on. This was the view taken in Sonu's case. Then came Safi Muhammad. In Safi Muhammad, complete contrary view has been taken, contradicting the P.B. Anwar. Here, the court has said, no, Section 65A and B, not a complete code, number one. Number two, applicability of section 63 and 65, not included, two. Number three, you have to, if you are not in a position to produce a certificate, you can revert back to 63 and 65 and prove the same as secondary evidence. This is quite contrary to Hon'ble. Therefore, in Arjun Pandit Rao, the case has been referred to a larger bench. Let us see what is the view of our High Court and as well as the few other High Courts. In our High Court, Ramajayam case, decided by Honorable Justice P.N. Prakash, there the question was, fortunately in that case, certificate under section 65B was not required because the original CCTV camera with recording was produced before the court, which means primary evidence itself was produced before the court, and therefore there was no requirement of getting any certificate under section 65B. So the Honorable High Court followed P.V. Anwar scrupulously and said that since primary evidence itself is available for the court, there is no need to resort to section 65B of the Act. Now, there are 2-3 judgments of our High Court, wherein our High Court has rejected the evidence following Anwar, and there are also views taken as per after Sonu, looking at the fact whether any objection was raised. So these are all the judgments. Now, we will go to the judgment of the Delhi High Court now on this aspect. Kundan Singh. With that, I will close. In Kundan Singh, the court went into the issue as to whether the certificate is to be produced when the computer output is produced along with the charge sheet, or it is to be produced at the time when it is tendered for evidence. The Delhi High Court took a correct view, in my considered view, that producing the certificate is purely procedural. If I produce the certificate, the character of the evidence is changed from secondary to primary. If I do not produce, it remains a secondary. This is purely procedural. When I want to use the same as primary evidence, I need to produce a certificate. Now, the certificate is required only when the document is tendered in evidence. There is a vast difference between a document being filed into court and produced in evidence. There is a vast difference. Section 62 says primary evidence means production of the original itself. So that question of production comes when it is tendered in evidence, when it is proved in evidence. At that stage only, certificate is required. For example, when a plaint is filed, you file a document. It is received and kept as a part of a court record, but it is not considered a tort at that stage. Later on, after the issues are framed, when the evidence is let in, the document is tendered for admission, tendered in evidence at that stage. So this is the second stage. Okay. Now, applying this, the Delhi High Court has said that when the document is produced originally, when the computer output is produced originally, though there is no certificate, that is not a defect. When the document is tendered in evidence, at that time the certificate can be produced. In a way, Delhi High Court was right in saying that the certificate need not accompany the document when it is filed into court. The document is required to be produced when the document is tendered in evidence. Suppose when the document is tendered in evidence, I am producing the certificate. If the certificate is found to be defective, the court rejects the certificate, then I have liberty to produce a fresh certificate also. At that time, I can produce a fresh certificate also. This is what Kundan Singh in effect has said. So as per Kundan Singh, certificate can be produced at any stage later. It is curable. It can be cured by producing a fresh certificate also. Now let us go back to the case which I cited before you, which we had the benefit of dealing with. Now keep all these legal discourses made by the Hon'ble Supreme Court in various judgments now in your mind. In the case which I told you, A1 gave instruction to A2 to kill so and so. It was recorded by A2 in his cell phone. So that is the primary evidence. Now he gives the same to a computer center, download the same and get a copy in a CD, in the form of a CD. Now the original cell phone of the sender as well as the person who recorded have been destroyed. What is available? Only the CD. Now, if Anwar's principle is to be applied, who will give certificate for this? Who will give certificate? You cannot compel A1 to give a certificate because it will amount to testimonial compulsion. Similarly, you cannot compel A2 to give a certificate. It will amount to testimonial compulsion because out of his best knowledge, etc., he is certifying evidence against him. You cannot compel him. They refuse. They cannot give certificate. Then so far as the computer center is concerned, then there also the what was downloaded on the computer has been now deleted. Nothing is found there also. Police investigated into that also. They found that nothing is there. Now what remains? Only the CD. Now who will give certificate for this? Who is competent to give certificate for this? If Anwar doctrine is to be applied, because there is no certificate, this is to be thrown. That's what we did. We were compelled to do. Now, if you apply Safi Muhammad doctrine, what Safi Muhammad has interpreted, if you apply that, in my view, the CD is admissible. And if it is once admitted, then the contents are to be proved in the manner known to law to prove the accuracy and to prove that there was no tampering and to prove that there was no manipulation, etc. These are all the other aspects of the matter. If suppose the party himself admits the document, when there is no dispute raised in respect of the same, where is the difficulty? So my humble view is that the document, that CD is per se not inadmissible. As held in Sonu's case, it is not per se inadmissible. Okay. As held in Safi Muhammad case, section 65B and 65A are not complete code, and therefore I can resort to section 63 and 65. The prosecution can very well say that original has been destroyed and therefore secondary evidence can be let in. This is the secondary evidence. It is admissible. As held in Ram Singh, the earliest case before 2000, 1985, and as held in Chandu's case, the accuracy of the document, the non-tampering of the document, the proper recording of the document, the contents of the document are to be proved in the manner known to law in commencing from section 59 onwards. How they are going to be proved is a different matter. But the document is admitted in evidence. The content, the court may say, after having admitted the document, the court may say that the contents have not been proved properly. Authenticity has not been proved properly. The recorder has not given evidence properly. It is one thing to say that the document has got no probative value, but at its threshold, how can you throw the document out? Is the question if Anwar is to be upheld. If Anwar is to be upheld. Now, what is today's position? Anwar is by 3-judge bench. Now, reference in this Pandit Rao case, Arjun Pandit Rao has been heard by again by a 3-judge bench. this three-judge bench cannot disagree with Anwar's view. What is Anwar's view? Anwar's view is 65A and 65B are complete code.
And
Anwar's view is 63 and 65 are excluded. Anwar's view is that unless there is certificate, under any circumstance, you cannot admit the same in evidence. This is Anwar's view. This view binds the present bench also. They can only overrule Safi Muhammad. But in my view, Safi Muhammad has interpreted section 65 and 65B and also 63 and 65 in the correct manner. So, but this bench, three-judge bench, may only overrule Safi Muhammad because they are bound by Anwar. Suppose this bench, being a co-equal bench, finds it difficult to disagree with Anwar, and if this bench likes to agree with Safi Muhammad, saying that Safi Muhammad view is the correct one, not Anwar, then this bench has to refer the matter to a still larger bench of Hon'ble 5 judges. 5 judges. What as of now, I feel, because I was sitting in the court when the matter was being argued, what I feel is that to remove all these anomalies, there are only 2 ways possible. One, this Hon'ble bench may deem it appropriate to disagree with P.V. Anwar, agree with Safi Muhammad, and refer the matter to a larger bench of 5 Hon'ble judges, and a constitution bench has to set the law, interpretation of the law rightly. This is going to happen after 20 years. This 65A and 65B were introduced in 2000. We are in 2020. So for all these 20 years, we have got only confusion. The law is not so certain, as it is expressed in this Arjun Pandit Rao referral order. Honorable Justice Bhushan has said that law requires certainty. Everything is uncertain. Please decide the issue so quickly. This is one way. There is another way. Having seen as to what is happening in this country, having experience of 20 years with this law 65 and 65B, why the parliament is silent? I am surprised. Why parliament has not taken any steps? Because it is their own law. It is their own wisdom to amend the law appropriately. Section 65A and 65B requires further amendment to obviate all the doubts which have been created in the legal brains. So either the parliament should immediately venture to amend this 65 and 65B appropriately, or the matter should be heard by a large bench of 5 Hon'ble judges and the issue to be decided. This is my concluding remarks.